Hey, all present, please go down with the justice of the appeals court. Now sitting in law, draw near, your attendance, and you shall be heard. Let's have the Commonwealth of Massachusetts, this court is now open.
Good morning and welcome to the Appeals Court. I am William Meade. With me today are Justices Hershfang and D'Angelo. Will be the panel for all the cases today. If you've been here before, you know that we've read everything. If you haven't been here before, you should know that we read everything. So my best advice is to get right to the point. And with that, I'll call our first case, Commonwealth versus Martinez. Ms. Opperman.
Good morning, and may it please the court, Erin Opperman on behalf of Mr. Martinez. We're here for two arguments today, and the first being the judge's exclusion of a statement denying the accusations that the defendant made 2.5 months before another statement he made that was admitted against him as consciousness of guilt at trial. The defendant raises two primary reasons why the exclusion of this statement was an abuse of discretion. The first being that he is entitled to rebut consciousness of guilt evidence, and according to the record and the argument put forth by defense counsel at trial, the statement that he made denying that he committed the crimes served to contextualize the statement he allegedly made that was introduced, that he allegedly made 2.5 months thereafter, where he asked his daughter to, quote unquote, cancel the charges.
He has a right to rebut consciousness of guilt evidence, but he has to do it with admissible evidence.
Correct, and I think the right he has to rebut evidence is part of the reason why this was admissible. I know that the Commonwealth argues that self-serving statements aren't admissible, and that usually is the case that denials of guilt are not admitted at trial.
Because they're hearsay.
Sometimes they are, and sometimes they're not. In this case, it wasn't offered for the truth of the matter that he, quote unquote, did not commit the crime. It was served to contextualize the statement that he made to the alleged victim, cancel the charges, to show that he asked her to do so, not because he was guilty.
Wait a second. You are asking that it be admitted for its truth, but you're asking that it come into as the exception to the hearsay rule for state of mind.
Correct.
So
Correct.
so clearly it's hearsay. You're asking that it come in for its truth, but you're saying it fits into the exception, correct? That was your argument in your brief.
I think it can be called an exception. I also think it can be called non-hearsay because it's not being offered to argue that he is innocent. It's being offered to show his state of mind when he made the statement. Either way, I don't think I need to argue about that specific point because, yes, it's either non-hearsay or an exception or both because it's being offered to show his state of mind when he made the second statement.
Do you have a case for us in which something that is that distant in time is offered as context for something else?
The cases that I cited in the brief, I believe they refer to explanations of so-called consciousness of guilt evidence that didn't necessarily occur close in time. I think one of them deals with a defendant's conversation with his lawyer about the crime itself. Other than that, I don't have a case that is close to on point to this one, where it is simply a defendant's out-of-court statement made 2.5 months prior to another out-of-court statement. But I think time is a factor in determining whether something can contextualize something else, but there's certainly no bright line rule that after this passage of time, it's no longer admissible. The second reason that it was an abuse of discretion to exclude this particular statement is under the doctrine of completeness. I certainly understand that the doctrine of completeness is just about always used to include portions of a writing or a statement that's made essentially contemporaneous with another statement. However, there are cases that suggest that there is a so-called continuing conversation exception or subsection, so to speak, of the doctrine of completeness. For instance,
I'm sorry, you have a case that says it doesn't have to be part of the same conversation?
I believe there are cases out of the appeals court that discuss Facebook messages being sent back and forth over the course of a day, text messages being sent back and forth over the day, and they refer to those conversations as a continuing conversation.
These were different conversations with different people about different subjects
I do understand that.
at different times.
I do understand that. This was raised by the trial court, and it is raised on appeal that it was an abuse of discretion. I certainly recognize that would be an expansion of the doctrine of completeness, but I do think it's important to remember that the purpose of the doctrine itself is to prevent the Commonwealth from presenting a fragmented version of a
Well, the defendant could have
conversation.
testified,
Yes, that is true.
and that would have been admissible.
That is certainly true. The second argument that the defendant raises is about the trial judge's failure to give a lesser included instruction of indecent assault and battery as to the rape indictment, and the two kind of paths of support that the defendant sets forth in his appeal is one, that it simply fell within the law for the lesser included instruction to be given in this case.
Well, there was no dispute as to penetration.
No dispute.
There was no dispute.
Well, the defendant certainly disputed it.
The defendant said it was a lie.
Correct.
He didn't say there wasn't penetration in the smaller sense. So if he was right that it was a lie,
Right.
he would be entitled to an acquittal, not to an instruction on a lesser included.
Correct. So I know that the case law says there needs to be some reasoning on which the jury could have acquitted on the greater offense and found guilty on the lesser offense. And I think that was present in this case, despite the fact that defense counsel didn't ask for that result. The defense at trial was...
So I want to focus on that for a moment because as Justice Meade's question makes clear, the law, the cases that we need to follow, including Commonwealth versus Donlan, say that for a lesser included, it requires some evidence that disputes or puts into question the element of penetration. So what was that evidence here?
So the evidence that put into dispute that element, as opposed to elements of a lesser included offense, are the attacks on the alleged victim's credibility. Most of the case rested on the fact that shortly before she made this allegation of rape, as opposed to witnesses seeing what could be fairly characterized as inappropriate touching, she had been seeking a U visa, she had a pending order of removal, and it was only after going through the process of trying to obtain help with her immigration issues that she then elevated or made this additional accusation of rape.
But assume that those attacks are successful and the jury or the fact finder does not believe her. The conclusion there is that she made it up, not that there was some kind of indecent assault that didn't involve penetration, correct?
I don't agree with that. I do think that based on the method of attacking her credibility at trial, coupled with the fact that there were witnesses who corroborated her additional allegations of inappropriate touching, that the jury could have found that she was being truthful, in part, and then lied about the extent of the act in order to bolster her immigration, her attempt at immigration relief by virtue of her status as a victim of a crime. But I think the other thing that was interesting in this case is that with the two indictments, the judge gave a lesser included offense instruction as to the indecent assault and battery, but didn't give it as to the rape indictment. And whatever reasoning the court applied and whatever reasoning this panel believes is appropriate, it really should have been applied equally to both indictments. So I think it could have really sent a confusing message to the jury that they were allowed to convict of a lesser included crime as to one indictment and not the other.
Well, the charges were delineated, right?
The charges were delineated?
Delineated from one to the other. I mean, one was an indecent touching and one is an oral rape, so
Yes.
there's no concern about unanimity. How could they be confused?
No, and it's not an issue of unanimity. It's simply an issue of sending a message to a jury that there's potentially a reasonable basis to convict of a lesser included offense as to indecent assault and battery, and there's not as to the rape indictment.
So there was a basis on the rape for an indecent assault and battery based on her credibility?
In part, yes. It was in part based on her credibility. However, I think the record shows that there was corroboration as to that
Did she
allegation.
equivocate about the rape?
No, I don't believe so. And the argument is in part because I think giving the jury a jury instruction on a lesser included crime as to one indictment and not to the other can simply be confusing, but that it also lends support to the argument that it was an abuse of discretion, that there doesn't seem to be any basis rooted in case law for having given the instruction, lesser included instruction, on one indictment and not the other. And if the panel doesn't have any further questions, I'll rest on my brief for the remainder of the argument. Thank you.
Mr. Farrader.
Good morning, Your Honors. If it may please the Court, Assistant District Attorney Timothy Farrader from Middlesex on behalf of the Commonwealth. And I'll just pick up where my sister left off, which is differentiating the two counts. Count 2, the indecent A and B count, covered a 3-year span where the victim testified to multiple incidents, some of which fell short of indecent A and B. I guess you could say attempted A and B, which would be A and B for lack of a better term, such as on pages 91 to 92 of her testimony, where she said the defendant tried to touch down and touched around her stomach, but the victim stopped her, and so it was essentially an actual factual basis for the lesser included offense on that charge, whereas a 3-year span with multiple incidents, some of falling short of indecent A and B. As to count 1, rape, it was a 2-month time span where the victim only testified to one incident, being the oral rape, and as the court has pointed out, there's no issue of penetration. Either the jury believed that it happened or it didn't, and under the case law, the judge properly decided not to give a lesser included on that count. On the first issue, the defendant's statements are just simply inadmissible hearsay with no exception. The doctrine of verbal completeness just simply doesn't apply because it's not the same conversation. This is 2 months apart, and this is not an abuse of discretion. There's no abuse of discretion to find that this did not explain or rebut any consciousness of guilt evidence.
What about his state of mind?
I don't think it showed, I don't know how this would show his state of mind. Denial to the police 2 months earlier would show his state of mind about why he told the victim to cancel the charges. They're just so far apart in time and unrelated. Someone can deny it to the police and then go to the victim and say cancel the charges, and it doesn't reflect on their state of mind at the time they made the statement.
Well, the consciousness of guilt sort of instruction and the why it's relevant is it's showing the defendant's intent, correct?
Correct.
So why isn't the defendant allowed to introduce a statement to show his intent as to why he made that statement?
Such as the case in Chase, he could take the stand and explain why he told the victim to cancel the statement, but his just simple denial to the police it just doesn't rebut anything. It doesn't give any explanation, any context, and I don't think there's any abuse of discretion here. I
Well,
think
the prosecutor argued
Yeah.
that the statement shows that he was guilty. It was conscious of his guilt.
Right.
That's the argument that's made.
Yep.
So why isn't the same type of argument allowable for the defendant to say, I made the using the prior statement to argue, I made that statement because she is lying?
He could, I think, as Justice Meade pointed out, he'd have to do that through admissible evidence, such as taking the stand and explaining why he made the statement. Just a denial to the police is just, there's no exception to the hearsay rule to allow that statement to come in. I think, as Judge Howe pointed out below, making a statement to try to intimidate a witness doesn't suddenly get in previous denials that would otherwise be inadmissible. I think that would really kind of flip the law on its head in this case.
Well, it's a little different than a denial. The statement was, I asked her to cancel the charge because I am innocent.
Right, but he didn't, there's no testimony to that.
Well, that's what the prior statement would at least allow him to argue, correct? As an inference.
Possibly, but I think it's an abuse of discretion standard, and I just don't think it gets to that level. Just someone can deny something to the police, and it doesn't show whether they're guilty or innocent. It just shows that they denied it to the police. If there are no further questions on either issue, I'll rest on my brief.
No, seeing none, thank you. Thank you both.
Thank you.
Our next case is 22P957 Commonwealth versus McCullough. Mr. Driscoll. Some judges will find them. I'm nice. Good morning.
Good morning, and may it please the court. William Driscoll for Kimberley McCullough. The Doyle error was sustained. I believe the Doyle error was shown and proven. Is there any reason for me to go over that part of my brief?
Yes, several. First of all, was there a motion to suppress in this case?
No, not that statement, no.
Okay. Can you point to me in the transcript where there's evidence that the defendant got her Miranda rights?
I cannot, because there was no such evidence that I'm aware of. However,
So let me stop you there. How do we have a Doyle violation when we don't have evidence of the defendant receiving Miranda?
because under Cobb, Under Cobb, at 518, there is a very heavy burden on the Commonwealth to prove waiver of Miranda. They had no evidence whatsoever about Miranda, so the assumption is that
Miranda... And that, Mr. Driscoll, would occur at a motion to suppress, not at trial.
In this case, Ms. McCullough was arrested on the street. She was handcuffed, brought to the station, booked, and thereafter she spoke with the officer who provided the Doyle violation information. At some place, either she knew she was under arrest.
Well, she may be under arrest, and they may be sloppy police officers and didn't give her Miranda, because until you get Miranda, you don't get the implicit assurance that what you don't say will be used against you. Only Miranda itself provides that. And we don't know when or if she got Miranda on this record.
On this record, there's nothing in there about Miranda. However, I believe it is very common knowledge, and it would be really a deprivation of her constitutional rights to say that the common person does not know that they have the right to remain silent upon arrest, because it's on the media.
I'll concede that more likely than not she got Miranda, but we don't know when. Meaning we don't know if it was before or after she spoke to the police, which is another problem with the Doyle claim, because she did speak to the police.
When she was arrested by a different officer, all she said was, "I have drugs on me."
Yes.
She did not talk about the incident for which she was arrested.
Yeah, but Doyle isn't parsed out by content or by recipient of the information. It's you either have remained silent or you have not remained silent. If you have not remained silent, then the assurances that Miranda brings with you are off the table. But more importantly, I think your argument here is what was the fellow's name? The officer Hart. Hart doesn't say that I asked her something and she remained silent, does he?
It is in the cross-examination where the prosecutor asked, did you speak with her? Yes, I did.
Let me clarify. It wasn't the cross-examination, it was the redirect.
Okay, redirect.
Which is significant here because on cross-examination by the defendant's lawyer, he's the one that asks the officer first whether the defendant spoke to her at the scene. And that's in the record of trial transcript 3, page 221.
And the officer testified that he did not have any contact with her at the scene.
So why doesn't that open the door to the Commonwealth then asking later on redirect, did she make any statements?
Because the only purpose for the statement that was made, obviously he did not speak to her on the scene. He spoke to her at the police station after her arrest and booking. Now, the only reason to ask her, did she say anything to you, when the Commonwealth knew that the answer was no, was to impugn and to show a consciousness of guilt.
But Officer Hart was in a car, right?
Driving the victim by for an ID, he did not.
Right, for a show-up.
Correct.
So we have Officer Hart and the victim in a car. We have your client and her co-defendant and at least one officer outside the car at some distance.
Correct.
So what is the prejudicial effect of making clear to the jury that someone who is in a car separate from the defendant did not have a conversation with the defendant?
That's not where the error occurred. The error occurred because back at the station, I had a conversation with her, and she told me nothing about what happened at the scene.
So
the scene being the assault.
I need to understand exactly which piece of Officer Hart's testimony you are claiming constituted the Doyle error. Is it on page 227 of volume 3 of the transcript where
Yes.
Officer Hart testifies in response to a question, but on scene you didn't interact with her? Answer, no. Question, okay, and she didn't say anything to you about what happened on scene? Answer, no. Is it that?
Yes, and backing up a line, and did you have much one-on-one conversation with Ms. McCullough? Top of 227, when we got back to the police station. So in other words, he had conversation with her at the police station.
And not on the scene?
Correct. And at that time,
Because he was in a car.
It had nothing to do with the car. It was back at the police station. So back at the police station, when you had that conversation with her, did she tell you what happened at the scene of the crime?
So I think
No.
what we have here is a misplaced modifier. So the question, she didn't say anything to you about what happened on scene. Are you interpreting the words on scene in that sentence to be attached to say anything or happened? In other words, do you understand that question to mean she didn't talk to you on the scene, or she didn't talk to you about what happened at the scene?
From the viewpoint of a juror, I believe they would say it would be the entire incident from at the victim's apartment through her arrest on the street. So on the scene would include, she didn't tell you what happened when the victim was beat.
She didn't tell you when. What conversation are we talking about?
The only conversation.
At the police station.
The only conversation with Officer Hart was at the police station.
So your argument relies on an interpretation of this question that is, when you were talking to the defendant at the police station, she didn't say anything to you about what had happened back during the incident.
Correct, bolstered by the judge's decision, who was there at trial, saying she sustained the objection on Doyle basis.
But then allowed a rephrasing of the question, and there was no objection to that rephrased question,
Correct.
and no motion to strike the answers.
Well, in my reply brief, I note that it would have been futile for defense counsel, after the judge had already said, okay, I'm going to strike this answer, and later on she decided not to. It would have been futile.
I don't know that she decided not to. She just didn't.
She just didn't, correct. And it would be a logical assumption to believe that she was going to, then she decided not to after a long conversation.
Why is that more logical than that she just forgot these things happen in trials?
Because on the top of 228, she said that, okay, I'm going to sustain the objection and strike the answer. Then it goes on for another page or so before it gets back to, okay, now we're before the jury and I'm sustaining the objection. Moving on, you can rephrase the question.
Wouldn't it have been appropriate for defense counsel there to stand up and say, Judge, can you strike the testimony? I guess I'm following up to Justice Hershfang. You're making a leap to say that the judge changed her mind as opposed to the judge forgot. And it's incumbent upon defense counsel to remind the judge, Judge, you're sustaining the objection. Can you strike the testimony? Isn't it?
Ideally, he would have, yes.
Okay, but he didn't.
True, and trials are fluid, a lot of things are going on, and things like this happen, and that's why there would be a substantial risk of miscarriage of justice standard had I been arguing that he should have done that. But that's not what I'm arguing. I'm arguing that his objection was sustained on the basis of Doyle error. And so it was preserved. Not going with the unpreserved failure to ask to have the answer stricken. And actually under a very strong dissent in Isabel, along with Cobb and Meade, the U.S. Supreme Court has, the Supreme Judicial Court has made a very strong statement about how these things should happen, such as the even if she had struck the answer and told them to disregard all stricken, which she did not do, that's not the same as a curative instruction. Yes, the judge does not have a sua sponte duty to give us a curative instruction.
Tell me, Mr. Driscoll, how was this used? When the defendant testified, was she impeached by the prosecutor with what she didn't say to Hart?
Her story was entirely different. Well, I should say the victim's story kept changing.
Was she impeached with what she didn't say to Officer Hart?
No, she was not.
So, assuming all the other components of Doyle are available, it wasn't used.
It was used with consciousness of guilt. And the dissent...
What she said, what she didn't say to Hart is consciousness of guilt?
Yes, so she didn't tell you what happened when this guy was beaten, and she was right there. She didn't tell you about beating him or that she didn't beat him?
Hart says, I didn't talk to her.
No, he did talk to her after her arrest. And back at the police station, he did talk with her. And talked with her at length. Did she say anything about what happened at the scene? No. In other words, so she didn't say that she did not beat him. She did not hit him. She did not have any idea that Juan was going to be coming in to do this.
Do you have a case that says that when the defendant chooses not to exercise the right to remain silent and speaks, there is still a Doyle violation with respect to talking about things that they don't speak about?
Yes. Indirectly, Isabel, dissent. Scathing, 4-3 decision, Chief Justice and 2 other justices came out and said that any consciousness of guilt evidence damages the defense.
You know, dissents are fun to write, but they're just dissents. They don't have precedential value.
They do have meaning, though. And
There's a couple of great cases in the Commonwealth's brief, Commonwealth versus Lodge and Commonwealth versus Sosa, that says, that answers Justice Hershfang's question. Did you take a peek at those?
no. But the warning in the dissent of Isabel is that we are not to allow the 5-part Meade test to dissolve into a substantial risk of a miscarriage of justice. That what is meant by substantial evidence is it must be truly overwhelming evidence, and here it was not. You had a victim, you had 3 witnesses, Officer Hart, you had the victim who was all over the place. He testified at trial to things he never told the police. He testified at trial to things that were not what he told the police.
But that's a credibility issue, right? That's
Which
for
was
the jury.
Which was the whole case. So when Ms. McCullough was testifying, and she gave her side of the story, her story made sense. It didn't have those inconsistencies. You either believed her or you believed the victim. And the victim was all over the place.
Right, and the jury gets to decide who to believe. We don't get to do that.
Correct, but if it wasn't for the consciousness of guilt, her
All right.
her credibility wouldn't have been harmed
Okay.
in that way.
We're going to have to hold you there. Thank you, Mr. Driscoll.
Thank you, Your Honors.
Mr. Locke.
Good morning, may it please the court. Michael Locke for the Commonwealth. There are 3 reasons why there was no Doyle error here, all of which the court has already noted. First, there's no evidence that Miranda was ever given or when it was given. Second, the defendant did not remain silent. She spoke to police and said, I have drugs on my person. She testified to that fact. It is trial, transcript number 4, page 38, where she testifies that, yes, that's correct, I spoke to the police and told them that I had drugs on them. And third, the comment here was clearly not a comment on her silence, because again, she spoke to police. The point that the prosecutor was trying to bring up here was he was trying to clarify something that happened on cross-examination of Officer Hart, where defense counsel first asked him, did you speak to my client at the scene? And he said no. And then later on, defense counsel asked, but she told officers at the scene that she had drugs on her, and he said yes.
Can I ask you about the very first thing you said about there are 3?
Sure.
And you talked about number 1.
Sure.
If a defendant is stopped on the street and a police officer asks him, hey, tell us what happened, not under arrest, not Mirandized, and doesn't say anything, and then later on is arrested, et cetera, is the Commonwealth allowed to ask a police officer, hey, when you stopped the defendant and said what happened, he said nothing?
I believe so, Your Honor, because again, there's no, Miranda isn't
Do you
implicated
have a case that says that?
there. Not off the top of my head, Your Honor.
So a defendant's silence, even before Miranda is at issue, can be introduced against a defendant?
I believe so, Your Honor, yes. In this case, it doesn't even matter, even if I'm incorrect about that. Again, here, the defendant didn't remain silent. She spoke to the police. So Doyle's out the window either way.
Well, he may have remained silent at the scene. In fact, I think that's what defense counsel sort of asked about. Did you talk to her at the scene? The answer was no.
Right.
So she remained silent at the scene.
She didn't. She spoke to a different officer at the scene. This is what the prosecutor was trying to clarify here, is that there was another officer on scene who the defendant spoke to, and this officer was just relaying what the defendant had said to that officer. And that's why this problem started on cross of Officer Hart from the defense attorney. As I said, she asked, did my client speak to you at the scene? He said no, and then later on, the officer then said, oh, but she said that she had drugs on her.
So redirect, under the case law, allows a lawyer to clarify something, correct?
Correct.
There was no clarification here. The question was, did you speak to Officer Hart at the scene? I'm paraphrasing. Answer, no. That's not clarifying, well, did you speak to another officer? That's what the redirect was.
So at least I'm getting confused here.
Okay, let me try to
Sure.
put it in order. Defense counsel says, did the defendant speak to you? Officer Hart's on the witness stand. Did the defendant speak to you?
Right.
Answer, no.
Correct.
On redirect, the prosecutor says, did she speak to you? Answer, no. Follow-up question, did she speak to another officer? Yes. That's not clarifying the question on cross or the first question on redirect. It's asking a separate question about another officer. Why is that permissible?
I think it is clarifying, Your Honor, because the confusion starts on redirect, because the jury is hearing the officers testify, no, I didn't speak to her, oh, yes, she did say this at the scene. So the prosecutor is trying to clarify where that statement came from, why that officer can initially testify that he didn't speak to the defendant, but he somehow has the statement from the defendant at the scene.
Isn't it the prosecutor who created the confusion based on the questioning? And you're not allowed to clarify your own confusion that's created.
There was no confusion until the defense counsel asked those questions on cross-examination.
I guess I'm missing what the confusion is. It's a pretty clear question. Did the defendant speak to you? Answer, no. That was the truth.
Correct. And
So
then
what's confusing about it?
later in the same cross-examination, defense counsel asked again, but she said it at the scene that she had drugs on her person, and Officer Hart testified yes. So now the jury is looking at going, how does he, where did that statement come from? So now the Commonwealth, the prosecutor, is just trying to clarify where that statement came from, and that's explained at sidebar, during the sidebar with the judge. The prosecutor says to the judge, Judge, I'm just trying to explain where that statement came from, because on cross, he said two conflicting things, which seem conflicting, which aren't, and need to be explained by the fact that she said it to the other officer on the scene.
Are you all done, Justice D'Angelo?
I am.
I have a question about the absence in the record of any evidence of the defendants having received her Miranda rights. What's up with that?
There was never a motion to suppress filed on that issue. That's, as Justice Meade stated, that's where this evidence would have come up. The prosecutor didn't have any idea that there would be some type of Doyle issue claimed at trial. Obviously, it would have been much easier if we had an idea of when Miranda was given or when it wasn't given. But we simply don't have that evidence. Again, there was no motion to suppress filed. Moving on, even if we'll go with, even accepting that there may have been a Doyle error here, any error was harmless beyond a reasonable doubt, nor was there a substantial risk of miscarriage of justice. I would argue that the error was not preserved. Again, this whole discussion with the trial judge, whether he struck it or not, if you read through it carefully, I believe the trial judge initially thought that the question did initially go to a Doyle thing. As they were talking it through, the prosecutor realized that the prosecutor was just trying to clarify the issue, and then that's why he didn't end up striking that testimony, because he realized, oh, he's actually just trying to clean this up. And the fact that the prosecutor did then clean this up, there was no error.
Then why was the objection sustained?
Because I believe originally that the trial judge believed that this question was aimed at a Doyle issue, that he was asking about the defendant's pre-arrest silence, but then once the judge talked with the prosecutor, realized what was going on, I would suggest when you read the transcript, you can see the trial judge understand, oh, I see what you're getting at now. I'm going to let you clean that up, and then we'll move forward.
But when they left sidebar, and I don't have the transcript, I'm basing it on what defense counsel said, didn't the judge say, I'm sustaining the objection, you can rephrase the question?
Essentially that, yes, but again,
So it's sustained.
it was,
If
but
it
that's
was not
why
a problem, why would it have been sustained?
my argument is that the judge realized that where the comment was going with it, and that's why it wasn't struck. So he initially sustained the objection thinking what was going on. Once he realizes what's happening,
You know, I was a trial lawyer for a long time, and I'm trying to figure out, sustained usually goes along with striking and vice versa. If it's not sustained, the answer stands, the jury can consider it. If it's sustained, the jury is supposed to disregard the question and answer, which is another word for strike. So I'm not following you here. Either the judge sustained it or the judge didn't. And on my reading, again, I'm basing it on, I think you both agree, she sustained it.
I believe the judge
Do a
initially
dramatic
sustained the
reading.
objection. Oops, sorry. I apologize.
I was just offering to do a dramatic reading of that portion of the transcript, because I do have it in front of me. You're right.
So I think that argument doesn't really hold water. It's either sustained or not sustained. The judge sustained it. Now, your argument could be the judge shouldn't have sustained it, and that one, you know, that I'll go with, maybe.
I apologize for not being clear, Your Honor. My argument would be the judge initially sustained it, realized that he should not have, he wouldn't have, once the Commonwealth presented its, how it was trying to clean it up, and that's all the question was, and that's why he didn't strike it, because he said, oh, I realize now what the Commonwealth's getting at, now you can go through it.
And actually, if this is helpful, which maybe it is, what the judge said was, I'm going to sustain the objection and rephrase it. But be careful. It's really just, you were asked on cross about, you were actually indiscernible narcotics that were found. So that's what the judge said. 229, volume 3.
I'll move on from that point. Again, here, any error would have been harmless and there was no substantial risk. I'll concede, not concede, even if there was an error here and it was preserved, the error was harmless. Here it was introduced, again, the error was introduced by defense counsel when she asked us questions on cross. The evidence of defendant's guilt here was overwhelming. The victim testified, the defendant called him, showed up, unlocked the door, said that here comes the defendant. Before the defendant comes in, she grabbed his backpack, she takes off, there's blood on everywhere. There's blood on her, she shows up 50, I think they get found, her and the co-defendant found 50 yards from the scene. She has the defendant's cell phone on her. There's additional evidence beyond that, but I would argue it's overwhelming. And finally, although there was no curative instruction here, the prosecutor did clean up the issue right away. So again, Commonwealth's position that there was not a Doyle error here, but even if there was, that such an error was harmless beyond a reasonable doubt. If there are no further questions, I would rest on my brief.
Thank you. Thank you both. The next case is 22P791, Commonwealth versus Ramirez. Ms. Hill. Go ahead.
Good morning, Your Honors. May it please the Court, Kathleen Hill for the defendant, Hector Ramirez.
Can you pull that microphone closer to you, please?
This?
Yeah, thank you.
Well, usually I'm very loud. The underlying problem in the issues of this case is a discovery problem. In fact, it's a discovery problem that we often see that's common in a lot of trial cases when there's videographic evidence. In this particular case, we're taking the position that there's a Brady violation.
How? Defense lawyer, at the time he asks that the videos be turned over, at least according to what we think we know, had already been destroyed.
Actually, I don't think it went that way procedurally. What happened? Procedurally, what happened is he was arraigned in November of 2019. In February of 2020, 4 months after this case started, the defense counsel filed a motion for a particular piece of videographic evidence that tended to corroborate the story of a defense, which would be self-defense. At that time, 4 months after the case had started, this puts the Commonwealth on notice. He specifically asked for all video cameras, angles of Voc 1, which is where this was over at Essex House of Correction. There were 4 cameras. Now, in every room and area that is video recorded, there are multiple cameras, not just one. There's multiple angles. So when the Commonwealth produced the videographic evidence of the actual alleged assault and battery in the lunchroom, there was one angle. And from that angle, you should have known that there would be other angles, and the other 4 angles of the lunchroom. So that
Can I ask you, well, putting aside whether that's exculpatory, the lost or destroyed videotapes were in the possession, custody, and control of the House of Correction.
correct.
And how is that part of the prosecution team?
Because part of the prosecution team was the investigator, Zachary, who had conducted the investigation for the Commonwealth. And the Commonwealth states that it relies on the police report. Well, you've got the evidence there from the officer, Zachary. He didn't interview my client. He didn't interview Mr. Cherry. He didn't interview the other 8 to 10 officers that were there. That's the right hand of the Commonwealth. They're obligated to make certain that all the evidence, whether it's relevant or potentially exculpatory, reasonably exculpatory, it should be presented and preserved.
So
Why is the House of Correction investigator an arm of the Commonwealth? Do you have any case that says that they are exactly equivalent to a local police department or state troopers?
I do believe I cited in my brief, I did. I usually cite because there's another case, a subsequent case, where the detective, the police officer, and the case law specifically states, well, it's in my brief, that they're the right arm of counsel, the investigator. In this instance, it's the sheriff.
A detective of a police department or a state trooper,
Yes.
case law is clear, that is an arm of the Commonwealth,
Yes.
that is an agent. This is not that. This is the House of Correction.
This is the sheriff. This is the sheriff.
Okay.
And so therefore, they're the right arm. And if you want to take the position that they're not obligated as the police department, that the sheriff department isn't obligated as the police department, you still have the fact that the Commonwealth produced a video that they should have known was only one angle of a lunchroom. It was the last second, the actual second of the alleged incident, and that there was more. There were more angles and more cameras. And by the time you're given notice asking for defense counsel as for Voc 1, you're putting the Commonwealth on notice that there's a potential self-defense claim here. And so
I just want to make sure I'm getting the timing. So the motion, the request, the motion for video footage was filed on February 20th of 2020.
yes,
On April 15th of 2020, so a little less than 2 months later, the Commonwealth informed defense counsel that the other videos were no longer in existence. Is there any record evidence of when they were destroyed?
yes. Actually, it's 1 year later that the Commonwealth notifies defense counsel that the videos were destroyed, because they notified them in April of 2021, and the request for all video cameras and angles was in February of 2020, 4 months after the arraignment. Also, too, now this will take us to leap forward between the two. If you take a look at the defendant's motion to have counsel withdraw it for a new appointment of counsel, I note that there, the prosecutor states, and that was the final hearing, final conference hearing, that trial could have appeared that day, on December 2021, counsel states that she had not yet viewed the videos, which is very telling. She's not even aware of what happened. She never even saw the initial scene, and she's supposed to be ready for trial.
You're talking about the prosecutor?
Yes.
Did you try a lot of cases in district court?
No, you're getting to the fact that you pick up a case and you try a case, correct. But then that would be all the more reason why, if you look at what Judge Brennan said during that motion session, have you tried to settle this case? Step aside and settle the case. And at that time, Judge Brennan suggested that in light of the fact that the video has been destroyed, that he would, if they entered a plea, he would consider giving a guilty file, which falls in line with what Mr. Ramirez is looking for, because he's looking for immigration consequences.
Counsel, how can we, in the record, determine when the videos were actually destroyed? Where is the evidence of that?
You do have evidence of that when Investigator Zachary is on the stand. He informs that they're only held for 6 months and that they were destroyed. And so when they're discussing it between the prosecutor and defense counsel, they're talking about an 18-month period, when actually it's 6 months, which makes it all the more important as to why a Brady violation keeps reappearing in all these cases.
So
we suggest that what should have been done is when you produce a videographic evidence, you specifically identify that video, meaning that you would have known what you're looking at and whether or not there were other camera angles and...
Okay, let's just assume for the purpose of this question that I agree that the other videotapes should have been produced. How did your client have a self-defense defense that would have been aided by those videos? My understanding of the evidence that was put in, and tell me if I'm wrong about this, is that it showed that there had been some kind of encounter between the victim and your client before they were in the lunchroom, that there may have been a continuation of whatever that dispute was heading into the lunchroom, and then by the time the actual assault and battery occurred, the victim was sitting in a seat in the lunchroom with his back turned, and your client came over and hit him in the back of the head with the tray. Do I have the facts right?
You do have the facts correct. And then what happened is, if you take a look at the video, and if you're looking at the video of the Voc room, when you go to see that this individual, Mr. Cherry, with his accompanying 3-4 other individuals that confronted Mr. Ramirez alone, you'll see it's an A. They're marked A, B, or C. You'll see where he's accosted in A of the video, where he points his finger within 2 inches of his face, and Mr. Ramirez tries to walk away. Then as he tries to walk away, Mr. Cherry comes up and grabs him by the arm. Still, Mr. Ramirez is able to walk away. They continue, they're escorted by various correction officers to the lunchroom, and it continues in the lunchroom, which Mr. Ramirez is saying. And there's also right before...
Whoa. Where do we have evidence that the commotion is continuing in the lunchroom?
We have this in the basis of why he's requesting new counsel. This is before Judge Brennan.
That's not evidence.
No, it's not, but...
So where is the evidence that the commotion is continuing in the lunchroom? The evidence is to the contrary, based on the court officer.
Yes, that's why I'm saying I think everything is merged kind of together, because what happens is you have his story where he's saying, I've got some exculpatory evidence that I was accosted. I'm not the first aggressor, is what Mr. Ramirez is saying.
Hey, counsel,
And then-
hold on. Shouldn't all of this have been flushed out either in a hearing about whether the evidence was exculpatory, destroyed, or in a motion for new trial, none of which is put in your brief at all?
Yes.
So
And that-
you're saying the defendant's statements to the judge when it's about counsel, we should consider that as evidence. We can't.
Yeah, I'm aware of that, and that's why I'm saying that was my third claim, my third claim was the Brady claim, which that was underlying the issue of why he moved for new counsel was specifically because of this destroyed video, and why counsel moved to withdraw, which are the two claims, the two strongest claims that I feel are made in this case, the errors that were made. And that is, they discussed about the missing video. The video, there were remedies that could have been done.
Isn't that an ineffective assistance of counsel claim?
It is or it isn't. So you would decide, do you need to file a motion for a new trial to do this? Or can you raise the issues on direct appeal through the two, by being denied new counsel and by being told that you have to withdraw?
Well,
And,
to prevail on ineffective, you're going to have to show that there was something substantial that the defendant was deprived of, which ties into your Brady claim. You have to show that there's at least a possibility that something in the lost or destroyed videotapes was favorable to the defendant. And I don't understand where that is, especially as Judge D'Angelo has pointed out. Ridley specifically testifies that he has a view of the entire dining hall, and he doesn't see any commotion, and specifically he sees no interaction between the defendant and the victim.
Well, you have, the evidence that you have is what was conducted at the trial. So you have that, you know that there's an issue about a potential self-defense claim being raised. So where was it?
Well,
Where's the motion
we also
motion-
have the testimony of the investigator who says that he looked at all the videos, and this one showed the best view of the incident. He doesn't say there were other videos that showed the altercations between your client and the other inmate. He doesn't say that. Isn't that a piece that would be important for your argument?
That's a critical piece in what Investigator Zachary says, because he's usurping the jury's obligation to be able to find facts. They were entitled to angles and to have angles of that lunchroom, everything that had transpired.
You're arguing that a jury is entitled to all of the video footage of any incident?
If it's relevant and if the defense has asked for it, and it's also mandatory disclosure, it should have been disclosed, so it's there. So there's a reasonable possibility that what Mr. Ramirez is saying is true. And how do we know that's also true? Because he said, there's more video, invoke one. And that turned out to be true. We could see that he was
but for self-defense,
accosted.
there has to be an imminent fear of bodily harm. Where's the evidence of that? Because he approaches the defendant who has his back to him.
And there is, I think, Your Honor, because you hear Mr. Ramirez say to the judge, "Judge, can I show you something?" Now, you don't know what Mr. Ramirez wanted to show the judge, but it's not until you get to sentencing that on mitigation, at sentencing, counsel says, "My client wants me to tell you that he was stabbed, and that the individual that stabbed him was not charged with this offense."
He didn't testify, right?
No, he did not testify.
There's no evidence of that.
But
Do you have any more?
but what it goes
I think we're going
to-
to hold you to that. Your time is up.
Thank you, Your Honor.
Ms. Jansen.
Good morning, May it please the Court. Catherine Jansen on behalf of the Commonwealth. I want to clarify quickly about the timing of the request for different videos. So the first request for the VOC 1 that defense attorney had made was allowed in February of 2020. That was provided, and then the Rule 17 that he filed for the additional angles of the lunchroom, that was filed on March 8th, 2021. That's at Record Appendix 21. That's his affidavit in support of the Rule 17 is dated. And then on April 15th, the prosecutor learned that the video didn't exist anymore.
So VOC 1, just so my understanding is clear. I see the motion, it's page 16 of the appendix. VOC 1 is not the cafeteria.
Correct. That's the housing unit, and that the video evidence of VOC 1 was admitted by the defendant as Exhibit 2, and it absolutely did tend to show that the defendant was being antagonized prior to entering the lunchroom. However, the cafeteria video, the one angle, which was Exhibit 1, and I believe the court allowed my motion to transmit the exhibits, so I would encourage the court to look at the videos. It is clear there that the victim is already sitting down at a lunch table with his back for a few moments, and then the defendant comes into the frame of the angle, puts his cup down on one table, and then walks right up to the victim and smacks him over the head twice with a lunch tray. So putting aside anything about whether or not the sheriff's office or the jail is within the branch of the Commonwealth, which I'm as part of the Commonwealth team, which I'm not sure it is, especially because there's a Rule 17 required for the video, there is no possibility that this lost video would have produced anything favorable for the defendant. I mean, that's unassailable evidence of that there was nothing going on between no ongoing conflict. Just because the defendant felt like he was justified in his actions because he was angry is not a claim of self-defense. And again, we have the video and we have the testimony of the corrections officer who's there. So it's not as if we just had testimony that was uncorroborated by a corrections officer.
So, again, thank you for clarifying the timing. Are you suggesting that the Rule 17 motion is not allowed, and taking the inspector's testimony sort of in evidence regarding that, the Rule 17 isn't allowed until after those videos would have already been destroyed?
So I quickly reviewed the inspector's testimony, and I missed that it was 6 months of how long they were preserved. Perhaps that was in the transcript. That was the first time I really looked for it while I was sitting at counsel's table, so I apologize. So I think the Rule 17, if we take that, if that's true, then yes, the Rule 17 was requested after.
And what was the date, the Rule 17?
The Rule 17, based on the affidavit filed by defense attorney, was March 8th, 2021, and that's at Record Appendix 21. And that accompanied, the Rule 17 didn't have a date, but the affidavit, presumably, that went along with it, would be evidence of that date. So in terms of, at the end of the day, if this is a Brady claim, which I don't concede it is, there was absolutely no prejudice to the defendant.
Can we move, we didn't really discuss it with defense counsel or appellate counsel, the issue of the motion to withdraw on the trial date. Put aside the initial hearing, the trial date. Do you think there might be an actual conflict for the attorney when he makes the comment that because he thinks the defendant may have filed a claim to the BBO or put his license in jeopardy, it is in his head, and I'm not sure whether it might affect me, and then the judge cuts him off and stops there? And that's page 2, trial transcript 2, page 6.
I don't think there's an actual conflict per se, and again, it's the defendant's burden to establish that there's an actual conflict per se, meaning the precise character of the conflict, and that, and also the divided loyalties. And so I would suggest that that burden hasn't been met here. I think at the end of the day, you need to say, would his representation be materially limited due to self-interest? And I would suggest that he would have even more of a zealous interest, even more of a zealous advocate, because this could be out there. But at the end of the day, I would also take that statement about whether this would affect me, I would take that more into whether or not he feels irretrievable breakdown of a communication or relationship between them. But again, I don't think that occurred here.
How do we know that? Because the judge at that point interrupts and then focuses on the defendant and starts asking, I would suggest, appropriate questions to the defendant about whether there's communication issues with his lawyer. But he never goes back to the lawyer. Shouldn't the trial judge at that point have said, I've heard everything the defendant says, he doesn't seem to have a problem with the communication. What about you, counsel? Shouldn't that have been done here?
I think
It has to work both ways.
I think flushing it out definitely would have been obviously a better course, but I think on this record it was not necessary because I think you need to look at whether or not at the end of the day this is going to create a divided loyalty, and I don't see how you create a divided loyalty by a potential threat of a BBO complaint. And again, the defense attorney didn't say, when the defendant clarified, I said I was going to appeal it. I'm not trying to like ruin his reputation or hurt his license. And the defense attorney didn't correct that was the tenor or nature of the conversation, opposed to a BBO
He wasn't really
complaint.
asked. He wasn't asked. So the judge didn't go back and ask him.
And I think the judge, like I said, better course or better practice maybe should have been, but the defendant's entitled to a fair trial, not a perfect trial or proceedings. And I think here, where basically if there's any claim of a BBO complaint, then I think this happens a lot in district courts, I think, with very, difficult clients sometimes, and there are lots of tensions and frustrations. I think I think that, should the judge have probably gone back and flushed it out? Yes, but here, I just don't see how there could be a divided loyalty that would...
Does it make a difference, do you think, the fact that this was the second time the lawyer had basically tried to get out of the case? Doesn't that go to maybe there is a problem here?
Well, I would disagree it's the second time the lawyer tried to get out of the case. It was completely the defendant, the first instance, trying to discharge his lawyer, and there was no claim that the lawyer also wanted to withdraw or that he was having trouble communicating with him or that he felt like their relationship was strained beyond the ability to help prepare a defense for him. So I think that's a factor. You have two ships passing in the night, basically. I think you have the defendant the first time being just angry because this video doesn't exist and he wants to have his counsel discharged. And defense attorney is not saying, yeah, you know what, this is causing so much problem between us, like we can't even talk about strategy or do anything. So whereas then at this time, quite frankly, this lawyer, I think, and again, it probably would have been better to flush it out, but was probably frustrated in dealing with, I think it's clear from the record, maybe a difficult client, stubborn in his viewpoint of the case. And here, if you're going to look at the irretrievable breakdown and whether or not there was that, you have to show, or a potential conflict. And I think if anything, it would be a potential conflict, not an actual conflict, because again, it's the defense's burden to prove this, that you have to show prejudice. And here, there's nothing in the record that shows that he wasn't prepared to adequately go forward on this case. I mean, the facts are what they are, and he did the best he could by highlighting the lost evidence that they didn't do everything that they need to do to get the video, and that the jury was not seeing the whole picture. So I think that that's important to look at when looking in the context of the entire case.
Assuming that he was threatening a BBO complaint, has this court or the SJC, including Tate, ever held that that creates an actual conflict?
An actual conflict per se, no. Tate cites that Douglas D.C. Circuit case favorably, admittedly, as what may create an actual conflict, but again, it's the defendant's burden to prove the precise character. And
it would have been dicta in Tate as well, right?
It's correct. So dicta in Tate, and this court, a panel of this court, which Justice Meade was on, and Garcia had found, again, it doesn't create there were actual BBO complaints from my understanding of the, I think it was a Rule 121 at that time, or Rule 20, I don't know, Rule 23. But either way, there were actual complaints made there, and the defendant hadn't met his burden to prove an actual conflict of interest per se, because he hadn't shown the precise character of the conflict, or that he had his representation would be materially limited by self-interest.
Didn't the counsel in Tate, didn't he tell the police where the murder weapon was?
I believe so. So it was pretty
That's a
big
problem.
breach of confidentiality that you would expect from your attorney.
In Fernandez, Commonwealth versus Fernandez, which talks about an actual BBO complaint, it's not per se, but that case, doesn't that talk about you need to find out what defense counsel is thinking about it? I mean, again, it's not a per se, but you have to agree that if the defendant has filed a complaint to the BBO and it's on the lawyer's mind, that
Well,
does affect communications. Maybe not, I understand what you're saying, it would make the lawyer want to do an even better job. I get that. But certainly that does affect communication between the defendant and the lawyer, doesn't it?
Well, and I guess Fernandez would be different in the respect that there was actual complaint, and here it was just the defendant spouting off stuff, and what he said was, I said I would appeal if the evidence didn't come out, and the defense attorney didn't, the defense attorney didn't come out and say, no, he threatened my BBO, which I know the judge probably should have asked more, but you would think if that was...
Hold on. Veiled threats about my license to practice law. That's what the lawyer says initially on page 6. That's more than just, I'm going to appeal him, isn't it?
I would disagree with that because I think oftentimes, if he thinks that he's going to say, I didn't do a good job, I'm going to have an ineffective assistance of counsel claim, I'm going to appeal this, theoretically, it doesn't happen a lot in practice, but your BBO could be at risk for being ineffective.
What did Ramirez say to the judge when they're discussing that, though?
I can't. I'm sorry, I just have to look in the transcript.
Right. It's not a trick.
Well, I just want to make sure I'm accurate, and
He doesn't want to do anything that will affect the attorney's reputation as a lawyer.
well, correct. So he doesn't want to hurt his license. He doesn't want his license or his reputation.
So you're saying that at that point, the judge could conclude that there needn't be any further inquiry of counsel. He could be satisfied with what his client just told the court.
Absolutely, Your Honor. And so further inquiry might not be necessary then.
Except there still might be a conflict with the lawyer having communication issues. Again, it's a two-way street. I think the judge in the questioning of the defendant may have, I don't want to say cured, but may have put a halt on one side of the street. But it works both ways.
And I'm not disagreeing that the judge could have fleshed it out more with the lawyer, but again, I think in this case, then you're talking about whether there's an irretrievable breakdown of communication and his ability to represent him, and I don't think you get that here for the reasons I've already stated.
Okay.
If there's no further questions, I'm happy to rest on my brief.
Thank you.
Thank you.
We're going to take a short recess.
All rise. Please be seated.
Good morning. Our next case is impounded, as you both know. 22P546, John Doe, 526500 versus the Sex Offender Registry Board. Mr. Hahn.
Good morning, Your Honors. So I'm going to focus my attention on the hearing examiner's denial of the motion for expert funds on the concept of neurobiological maturity. Now, the terminology around this concept can be a little bit all over the place, and I would acknowledge that in the moving papers there's some degree of confusion of terminology as well, so I'd like to sort of cut through the murk of it. And I would say that in the aggregate, the expert funds motion, the affidavit in support, and the scientific papers make clear that that's the concept at issue here. And simply put, neurobiological maturity relates to whether or not someone's brain development is at the point that we would consider adulthood. Now, to be clear, this concept does not relate to whether an offender or a defendant in a criminal case is a de facto juvenile. That's not the gravamen of the concept.
Didn't the motion, though, refer to Doe as a juvenile?
You know, Your Honor, absolutely true, and I will concede that. I would say, though, that the affidavit then refers to adolescent, and some of the scientific papers do refer to the adolescent comment. So I think there's...
Will you also concede that he's not a juvenile?
Oh, yes, Your Honor, of course. He's 18 years old. And I think so I would acknowledge, I'm trying to be candid about the motion, but that's why I said in the aggregate, I think it's fair to state that the motion spoke to this concept, and I think that the court could take cognizance of that. And so again, the concept, and it's a very, very interesting one, which the SJC has directly in their crosshairs in the Watt case, which I'll talk about in a sec. But based on that case, which deals with this concept as it applies to persons 18 to 20, it's clear on that alone, Your Honors, that this is not limited to people under 18. Now, in denying the funds, the hearing examiner, and again, I do acknowledge what the motion said, but I believe her expertise could have led her to conclude, should have led her to conclude that this was about a broader concept. The examiner herself...
I guess the problem, and you've already conceded that Doe is not a juvenile, and the legislature in the enabling legislation says that he's not a juvenile, and the regs under which the hearing examiner has to work says that he's not a juvenile, and the board treats adults differently from juveniles.
Yes.
And
excuse me.
Why was it a mistake not to conclude that he should be treated as an adult since he was an adult?
Certainly, and I'm not at all arguing that he should not be treated as an adult, because I do think it's clear from Watt alone that this concept applies to adults as well as juveniles. The term adolescent becomes a little bit unclear and a little bit confusing because we know if there's a Venn diagram between adolescent and juvenile, there'd be crossover and then there'd be points of not crossover. So the term juvenile is clearly established, as I would agree, Justice Meade, with that entirely. Adolescent, the other term, is not as clearly established at all as a scientific concept or a legal concept. But we do see multiple references in the literature to it being applicable to adults as well. And we see this court, a separate panel of this court, referring to the World Health definition, World Health Organization, as being through age 19. And as I've cited in the brief, there's actually a federal statute out there that refers to adolescents.
You referenced the World Health Organization?
Yes, Your Honor.
In a published opinion?
It's a Rule 128.
Thank God.
Yes, Your Honor, and I acknowledge that in the brief. But I would say also in the literature, the term adolescence refers to people, as older. And so the hearing examiner, I think, notably, to her credit, acknowledges this literature. She specifically acknowledges it, literature stating that brain development can continue until about the age of 25. Her language, she says, these papers say something imperative about adolescent brain research. But she then goes along to say, since these articles refer to adolescent brain development, she can't consider them at all because that means he's a juvenile. So she is conflating these terms in a way that I don't think is...
But to get the funds, you have to show that the expert would be able to help in a connected to a condition or circumstances that's special to Doe.
Sure.
And so the juvenile research is not special to Doe, who's an adult.
And so, Your Honor, I don't mean to be at all contrary to the court, but I guess...
That's why we're here. Go.
Thank you, Your Honor. But so what I'm trying to state is that this concept of neurobiological maturity does apply, certainly applies to persons over 18. I think that's...
To adolescents.
Well, Your Honor, so yes, except that I think the term adolescent confuses us in this discussion.
Okay, how about we say age 19 to 25, which is your client?
Sure.
So we have to find that the fact that the person is 19, between the ages of 19 to 25, that has a bearing on what? What factor?
And we could say 18 to 25 since he was 18 at the time of the hearing. So it's going to relate to his risk of recidivism, which of course is at the core of any SORB proceeding. So as a matter of common sense, as much as anything else, 18-year-olds, their brains are developing. And I think that is fairly well established in the scientific literature. So this concept of neurobiological maturity, which the SJC has recognized in a very sort of similar procedural posture of expert testimony, is going to be a condition that relates to this individual. I think quite clearly, because if the SJC says that expert testimony is warranted for persons 18 to 20...
For purposes of lifetime parole, not for recidivism as a sex offender.
Certainly, Your Honor, and I did anticipate that question, and I would state...
That's what the case says.
Well, Your Honor, certainly, but what I would note, and again, just in the spirit of making the argument, which I think is a reasonable one, SORB cases involve a protected constitutional liberty interest. That's been amply clear for quite a long time. The SJC reminds us of that vigorously. Very often in these cases. So I would not find it to be, let's say that when Watt comes down, when they took the expert testimony and now they've got it under advisement, if the SJC says that people 18 through 20 are neurobiologically immature, to think that would stop at the waterline of the life sentences, I'm not sure, and I recognize the courts, your honors are the ones to wrestle with that, but I would not say per se at all that where you've got liberty interests in SORB cases and in life sentences. I mean, a SORB, registration requirement can last a lifetime.
So I want to take you to the next step, because I think we understand the argument that essentially your client was legally an adult, but there is some period of brain development, which may be called adolescence, during which someone who is legally an adult may not actually be all the way there yet in terms of their brain science, right? To put it in very basic terms. Assume for the moment that all of that is true. Why was it either an error of law or not supported by substantial evidence for the examiner to decline funds for this investigator?
Sure, Your Honor. And I think the standard would be abuse of discretion on that. Substantial evidence goes to sort of the factual questions that would follow from that. The standard on a expert denial is it's an abuse of discretion if it sort of deprives the tribunal of information that could be material to the question of the recidivism risk. And so here again, we would have a scenario where the testimony would have been, perhaps, and we don't have the testimony, but there's indications it would have been, that we have an individual who's 18. He's not neurobiologically mature as an 18-year-old. He commits these offenses, very serious offenses. Then he goes to prison, and he ends up age 24 before the tribunal. That in that interim, he is perhaps going to reach a greater stage of maturity such that his recidivism risk is substantially lowered.
There is no affidavit in the record from the proposed expert, is that correct?
That is correct, Your Honor. It is counsel quoting his communications with the expert, yes, Your Honor.
And the expert, obviously, because the funds had not been provided, did not actually examine Mr. Doe.
That is correct, Your Honor. We have an earlier evaluation from Dr. Durant in 2017. But yes, in these cases, the experts, they're not going to do the work until we procure the funds, Your Honor. Yes.
So when you say that the evidence that was denied your client is evidence that would have shown that his brain hadn't matured in the intervening years, that's not based on actual expert evidence about this particular individual.
So we do not have an affidavit. I think, as Your Honor's question indicated, so we're probably not going to be able to get an expert to do an examination. It is true that in my hearing cases, I'd communicate with the expert, provide documents and so forth, and get a robust affidavit. And as often attorneys are forced to do a little bit of work on the chum, if you will, the experts will as well. So that would be the gold standard. I think ultimately I think there is an argument, there remains an argument, again, based on the aggregate of the motion and the affidavit to support this motion. I do understand Your Honor's question, however, certainly.
In your view, should expert funds be provided in any case in which the person who is offended was 17, 18, maybe even 19, but we need not go there at the time of the offense?
So I think that it would have to be on a hearing-by-hearing basis. There could be certainly cases where that expert testimony would not sort of go appropriately to the matter, and where it maybe even wouldn't be sought. But I think it's a reasonable, if I had obviously with an 18-year-old client, I don't think it's a particularly close question that I would attempt to do so. If it's, for every 20-year-old client, and forgive me, Your Honor, but I would, my memory is jogged, that Dr. Durant herself does talk about this issue in her 2017 report. So we have kind of a predicate there. So if it were me, in any given case, would I raise my hand and say, Madam Examiner, I should have expert funds on this concept? Probably not, but in a record like this one where we have Dr. Durant already saying that this is not a man with a serious mental illness.
You say on appeal that the hearing examiner failed to properly or adequately consider the evidence presented by Dr. Durant, but was that presented below?
So I noted in my brother's brief, it said that is not cognizable appellate argument, that line, I believe. So was it, if it was not raised below, my apologies, because my intent would ordinarily.
Can you answer directly, was it raised below?
I don't, as I sit here, I don't know. I'm willing, so you're saying, was the issue?
When the SORP says that it's not raised in your brief and you come here to argue, wouldn't it be ordinary course to check whether or not it was raised below?
Certainly, Your Honor, and I take that seriously, your remarks on that. It is, not the focus of my argument, because I do acknowledge that, sort of that's an evidentiary matter, and I apologize.
Well, I mean, on the merits, Duran considered considered Doe to be a juvenile, and that's why the hearing examiner didn't give it much weight.
Sure. Well, but I don't think, Dr. Durant's report, I guess it's, again, the same kind of conflict or confusion about whether or not sort of testimony or opinion or any kind of raising of that issue is appropriate with a non-juvenile. I would say it is, and I'd say Watt says that, and if the court has no further questions, I'll rest in my brief.
Thank you, Mr. Hahn.
Thank you, Your Honor.
Mr. Shinai.
If it pleases the court, David Chennai for the board. I started off by saying that I had June and July and August off, and now I have 4 cases in 5 days. So I think.
Come back.
Well, I think you're trying to wipe out my caseload in one fell swoop. This is actually a really nuanced issue, and I only say that because it reminds me of when the issue was raised about female sex offenders, and that the board at that time had no regulations about female sex offenders. The court didn't rule that being a female sex offender, there was a condition that was circumstance that was specific to that person. But what they said is that in Doe 205614, that if they put forth evidence through studies, for example, that show that female sex offenders differ from male sex offenders, the hearing examiner had to consider those studies. And the reason was, before that, the hearing examiner would say, I don't need to look at those studies because female sex offenders are treated like male sex offenders. The second one was Doe 151564. I'm not sure if it was the appeals court or the SJC version of that, but again, the issue was if evidence is brought up through studies regarding something that the board's regulations do not consider, the hearing examiner has to consider those studies in the decision making. The problem we have here is the studies, I don't think were introduced into evidence, they were part of the motion, but more importantly, none of them actually address this idea of the emerging brain on sexual recidivism. The closest that comes is one study that studied juveniles who are 2.5 years out of a secured facility and their recidivism rate. And that study, in this case, wouldn't be applicable because the individual had not been even released from incarceration at the time of the hearing classification analysis or hearing. But I think what's most important here is just because there's a concept of an emerging brain doesn't necessarily require expert evidence. What it requires is studies to be put in to show that there is ample evidence or scientific research into this area, and that's really lacking at this point. Now, I've been reading all of these emerging study issues, and I think it's interesting, you see they're so varied. One of them says that the emerging brain is from the age of 18 to 30. Hansen limits it to 25 and says, but what's interesting about Hansen, which I think is important, Hansen says if there's a conviction between the age of 18 and 25, this individual's merger into general criminality takes 10 years. And that's important because what Hansen's doing is he's doing lots of research on when does an individual who commits an offense, when does his recidivism risk, whether it's general or sexual, when does it get to the average of the average criminal defendant or criminal, or average criminal defendant, what their circumstance would be for recidivism.
So if the motion or the affidavit had put in studies that show adolescent sex offenders have much lower sexual recidivism rates, less deviancy, and are more amenable to treatment than are adults. If that language had said adolescents instead of juvenile, you would suggest it would have been error to not allow the expert funds.
No, what I'm saying is that it was not a basis for expert funds, because that doesn't, just because you're a 18 or 19-year-old, that emerging brain isn't just a condition that's specifically to you. The issue is those studies should be introduced into evidence for the hearing examiner to consider. Now, in the female sex offender case is a good example. When enough body of evidence came in and the courts ruled that it had to be considered by the hearing examiners in the decision-making, the board's regulations were updated to actually incorporate these studies and have separate factors for female sex offenders. I think that the way to do this is if you can get enough body of studies specifically regarding the juvenile brain and sexual recidivism through specific ages, then at some point the board would have to consider it. We just haven't reached that level yet of studies in that area. The emerging brain has been more about general criminality. And again, one of the problems with the emerging brain issue is that the things that the studies show is that individuals during the emerging brain are exhibiting behavioral characteristics that are actually, under the board's regulation, increasing of risk and danger because it's antisocial and it can be very compulsive behaviors, no thought processes, risk-taking. So the emerging brain doesn't necessarily reduce an individual's risk. And without further studies that say the contrary, I'm not sure the studies that exist right now really would help during the emerging brain. But I think there's a safety net now because individuals every 3 years have a right to a reclassification. So if theoretically a 20-year-old who commits a sex offense and by 23 his emerging brain issue has been resolved or is resolving itself, theoretically it can be tracked by their behaviors, which would be introduced into evidence at a future reclassification. And if at 23 it isn't sufficient, at 26 he would have another chance to show that his maturity level has reached a certain degree. So in some ways, the regulations inadvertently, because the court forced the 3-year reclassifications, had inadvertently given somewhat of a safety net to that emerging brain issue, showing that maybe they are no longer individuals who are compulsive or risk takers or don't think forwardly in their decision-making processes.
If Doe had funds and had hired an expert, would it have been permissible for that expert to testify regarding this issue?
Of course, I've had experts testify as to this issue.
So why should Mr. Doe be penalized because he's indigent?
I don't think it's a penalized issue. Again,
Well, if he had money, you're saying that an expert testimony on this issue would have been relevant and admissible at the hearing. Because he's indigent, he cannot get that expert to testify.
what I can tell you is that those who have testified as to this issue, the hearing examiners haven't agreed with the position of the experts based on the current research that's there, and more importantly, the fact that the regulation specifically defines juvenile and non-juvenile offenders. And again, until the body of research changes, those experts who do testify have not had much leeway or headway with this issue with the board.
They may not have much headway, but if it's relevant and admissible, according to hearing examiners, with people who have money, why isn't it relevant for people who don't have money? Because that's what the hearing examiner potentially precluded here. Because I am not going to give you the money because it just says denied.
Mm-hmm.
But if you had money, according to what you just told me, I would allow the expert to testify.
But I think and where the rubber hits the road is that, sure, anybody can testify, any expert can testify that's paid for because there's no rules of evidence. The problem is, and it's the word relevant, it's not relevant information being given. Just because an expert's testifying doesn't necessarily mean what they're testifying to is relevant. And under the board's regulations and where the research stands today, an expert testifying in that issue, it's not going to be found relevant by the board.
Can you clarify for me, when can a hearing examiner preclude a witness from testifying at these hearings?
Only when the hearing examiner determines that it's irrelevant to the hearing.
So isn't the corollary to that, if I allow the witness to testify, the evidence is potentially relevant?
Theoretically, the issue here is that the hearing examiners never strike anybody from testifying to whatever.
That
So
might be a
that's
problem
in
with the hearing
practice.
examiners, but
Correct.
I am struggling right now with, you are treating someone who's indigent differently than somebody who's not indigent.
No, because
Well, yeah.
No, no,
I just asked you a
Right,
point-blank
and
question. If you have money, this expert can testify. If you don't have money, I'm not going to give you the money to allow that person to testify.
But you have to go back to DOE 89230, which specifically says that the burden is on the offender to show that he has a circumstance or a special condition or a condition that's special to him. The emerging brain theory is not something that's special or to an individual of that age group, whichever age group they claim that it is. So under DOE 89230, it's specific, that case is specific that under those circumstances, the board is not required to use its discretionary authority to grant expert witness funds. That's the issue here is DOE 89230 is specifically said if someone gets an expert who's going to come in and testify just because they have money, it doesn't necessarily mean that a non-indigent would be prejudiced because the line is whether or not the individual who's seeking the funds and is indigent can show that they have a special circumstance or condition that is specific to them. And again, the emerging brain theory, and that's what it is a theory, isn't specific to individuals. It's specific to age groups. So under DOE 89230, the board still is not required to give expert funds in those circumstances. And the reason is that the SJC has made it clear and the legislation made it clear that these cases aren't supposed to be battles of experts. That's, this isn't someone going to be incarcerated or civilly committed. This is a procedural agency decision regarding whether or not an individual has to register and at what classification level. And again, it's not to be a battle of experts, and that's what DOE 89230 stresses. It's really to give funds when it's particularly necessary, not just the general funds to have someone come in to give an opinion, a risk opinion on somebody based on theories.
Do you think it's wrong for hearing examiners to allow this type of testimony from an expert?
I have found it's better that they let the testimony come in, deal with it in their decision as even if they determine to say it's irrelevant, rather than raise appellate issues at the Superior Court level. I'm a firm believer that the most important thing about these cases is if the offender has evidence, all that evidence should come in, just to let the hearing examiner sift through it, find out what's relevant, what's not, and make a fair decision. I've had people show up on the day of the hearing with additional evidence. I never object to it. I can't say that's the policy of every attorney in the board. There's conflict on that, but it's my belief if you want to make a fair decision, because again, this does impact the individual, it's always been my belief that it must be fair, and if it's fair that they have information, whether it's relevant or not, they should at least be able to put it into evidence and let the hearing examiner look at it and decide. That's just my opinion on that. Again, I can't speak for the board on that. Other board attorneys have other opinions on that. So unless there's specific questions, I think that I've covered these issues in my brief and would rest on my brief.
Thank you. Thank you both.
Thank you.
Thank you. Our last case is 23P434, Department of Children and Families versus Mother and Another. This, of course, is impounded, as you all know. Mr. Robin.
Good afternoon, Your Honors. May it please the Court, I'm Jeremy Robin. I represent the appellant mother in this child welfare case. Let me begin with this. This is a mother who was seriously afflicted with mental health illness, intellectual disabilities. There's no dispute there. She had severe psychotic episodes, required hospitalizations for these mental health afflictions, and had acted inappropriately on multiple occasions with the DCF, threatening one with a stick one time, even with her children, gave them nicotine gum, gave a very young child a lollipop. There's no dispute of that, the extent of her mental health problems. But that's not the issue here. The issue is whether the trial court prematurely terminated her parental rights with these 3 children where the DCF failed to give her the tools, the services that she needed to succeed. This is not your average parent. This is a parent who has deficiencies, whose deficiencies were clear to the department, were clear to the trial judge, but the department failed to use these so-called reasonable efforts in giving her the services that she needed to succeed as a parent. And that's why we don't challenge current parental unfitness. We're here to challenge only the termination of her parental rights. What services were these that would have equipped her to be able to adequately, again, it's adequately, it's not being the parent of the year, it's adequately parenting her children? Well, there was never an ADA meeting, and this was fleshed out in the testimony of the department's ongoing social worker, where she acknowledged that there was never this ADA meeting. What could an ADA meeting have yielded? It could have yielded specifically tailored services for a person who was suffering, who was crying out for help. She couldn't parent her children on her own. She didn't have the abilities, but she made efforts. She attended every day of trial. She engaged in services when she could. She visited with her children, but as I say, it was imperfect. And there were times when the manifestations of these mental health issues were clear, very odd behavior at best, and I highlighted a couple of those.
I want to ask you a factual question about one support that the department did provide. Both you and your sister note in the briefs that there was a time period, I don't know how long it went on, when the department was giving the mother a calendar with her visit days pre-marked in advance. Is there any evidence in this record of whether or how that affected the mother's attendance at those scheduled visits?
I don't have an answer for that question, Your Honor, but I do know this. A parent aid was not provided, and that was a specifically tailored service and a request that was made. And
when was the request made?
I don't remember a time frame of when the request was made, but I know that it was made, and the mother herself testified at trial that she would have wanted and would have embraced this service. Again, we're talking a flawed, imperfect parent, so the extent to which she would have engaged with this parent aid is somewhat unknown. But that was a service that was not provided, and I want to draw a line, a parallel line here with adoption of Darlene, which takes up much of my brief here because that is a case that has many similarities with us here, where you had a flawed young parent, mentally, intellectually, our mother here, IQ of in the 60s, That's a very low level of functioning. That's a person who's crying out for help. And in Darlene, your dissenting justice specifically said, we can't know the answer to the question of whether this mother will ever be able to parent because she wasn't given the equipment, so to speak, the services, what she needed to succeed. It wasn't given to her.
The dissenting judge in Darlene emphasizes that the mother had engaged in the services that were provided to her, and that it was clear to him on the record that if additional services had been provided, she would have taken advantage of those services. Do you see that as a necessary part of his conclusion?
Do I see that as a necessary part of the dissenting justice's inclusion?
Yes.
That would make sense to me. I would say that there's a parallel here because the subject mother here did engage in services. Did she perfectly 100% engage in every single service that was presented to her? No. Did she reject services at time? Yes. Did she say, look, I don't have psychological impairments? Yes. But isn't that part and parcel of a person who in fact has these serious mental health issues that they don't want to use the labels and the terms? It's embarrassing. It's humiliating. The mother did engage in services, and that's referenced on page 12 of my brief. She engaged in psychiatry. She engaged in therapy. She engaged in a parenting class. But these are more boilerplate type services. They're not the specifically tailored services that she really required to have a chance to succeed. She was never given that chance. The department removed all 3 children at a very young age, and the trial judge, unfortunately, sanctioned that. And they sort of did the song and dance, but they didn't comply with the real spirit of reasonable efforts. Before the department can terminate, and that's a very big step, that is forever ending the relationship between the mother and the child, there has to be more. There has to be more than here. Just engage in some parenting classes during COVID, online. Here, just, do the cut and paste therapy, psychiatry, fine. We know you have mental illness. No, the ADA meeting would have fleshed out the specific things that a person with these diagnoses, with these behaviors needed. That was never done.
Was the reasonable efforts argument made in the trial court?
It is raised, yes. And I know that the trial counsel specifically, and I noted this a bit earlier, fleshed out from the social worker these questions. And the social worker acknowledged that the DCF failed to schedule a specific Americans with Disabilities Act accommodation meeting.
I'm asking a broader question, though, not about the ADA meeting specifically, but about the reasonable efforts. I understand you to be arguing, maybe I'm wrong about this, that part of reasonable efforts was the ADA meeting. I also understand you to be arguing that there are additional things the department should have done as part of its reasonable efforts. You've mentioned a parent aid, among other things. Were those arguments raised in the trial court, and if so, can you point me to where?
When you say arguments, is the question, did the lawyer make that argument?
Yes.
I believe that was in the lawyer's closing statement. I believe she did reference, obviously that's not evidence, but I believe she did reference that the department failed to make the requisite reasonable efforts. If there are no other questions, I'll rest. Thank you.
Thank you. Ms. Braithwaite.
Good morning, members of the panel. May it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I am...
I'm sorry, could you bring the microphone closer to
Oh, my
There you go.
apologies. Better?
Much better.
I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I am here today asking you to affirm the decrees issued by the lower court. The court's decision in this case was the right one. My brother argues that the mother argues that the department failed to make reasonable efforts to restore her relationship with her children, placing great emphasis on the department's not scheduling an ADA accommodation meeting, and also pointing to a number of services which she argues for the first time on appeal should have been offered to her. Mother's reliance on the importance of an ADA meeting is misplaced. An ADA meeting is an opportunity for a parent, often with counsel, to meet with legal and clinical staff from the department in order to ascertain what accommodations can be put in place to support the parent in light of their disability. Per department policy, this is appropriate when necessary to discuss a parent's disability-related needs and requests for reasonable accommodation, or to review a disability-related complaint and discuss potential resolution. An ADA meeting is not always the appropriate avenue to reach this, and where mother insisted that she had no disability, requested no accommodations, and refused to work with the department, the record does not support the conclusion that an ADA meeting was the appropriate means by which to determine what accommodations would best serve her. And mother points to no legal authority for the proposition that an ADA meeting is required or appropriate in all cases of mental health disabilities.
So that raises a question that I think your brief also raised in my mind, which is, I think what you're saying is that it would have been the mother's obligation or her attorney's obligation to request an ADA meeting?
Generally speaking, that's the way in which it happened, but if mother was acknowledging that she had a disability, I don't think the onus has to be on mother to do it. The department engaged in countless efforts to discuss with mother her need to engage in mental health treatment and to have appropriately tailored services. Mother refused to do that. I also think a relevant part of this answer is that mother was asked from the beginning and referred to neuropsychological and psychological testing. And the reason that that's important here is because pursuant to the department's policy, the department is not permitted to make diagnoses. So while the department may be seeing evidence of a disability, the department cannot say to mother, you have a disability, if mother says, I do not. They can simply say, what we observe, we believe that you should engage in these services. So the neuropsychological testing, the psychological testing would have enabled the department to say, now we can better tailor to what you need. Ultimately, when mother refused to engage in any of that testing, mother was then referred to work with the Department of Mental Health, where those individuals are expert at diagnosing mental health disabilities. So I don't want to say that the department shouldn't have had an ADA meeting if mother was open to it, or that it was incumbent for her to ask for it in order to have one, but there is no ADA meeting that can be held while mother refuses that she has a disability and insists that she wants no accommodations, because that is the whole purpose of the ADA meeting. My brother indicates concern with the court's findings not referencing the testimony, which indicated that no ADA meeting was scheduled. But in answering that same question that was put before the social worker went on to explain that there were other ways that the accommodations necessary were determined. Even though mother didn't acknowledge she had a disability, what that certainly did not do was limit the department's obligation to provide services tailored to mother's needs as we observed them. And so there were a number of ways in which we did that. Mother's clinical team consulted with the department's mental health specialist regarding this case, and there was testimony that the clinical team met regularly, far more commonly than on an average case, in order specifically to address mother's mental health and cognitive needs and to ensure services and recommendations were closely tailored. Mother was referred to a parenting class for individuals with cognitive limitations and mental health challenges. Mother's action plan required her to seek psychiatric treatment and attend therapy. I would argue that those are not boilerplate tasks for someone who's suffering from mental health challenges, but in fact it was crucial that she engage in therapeutic services. As I indicated, mother was referred to work with the Department of Mental Health, and they too are another means by which reasonable accommodations can be identified.
So I want to ask you about the timing of that, because you noted in your brief that the mother's case was transferred to the department's specialized mental health unit in August 2016.
That's correct.
And then that there was a mental health consult conducted by the department in October of 2021. That's a 5-year difference. What is in the record about what, if anything, the department was doing during those 5 years to address mother's obvious mental health challenges?
So in that time, as indicated, mother was repeatedly, I mean, every conversation that was had, mother was asked whether she had engaged in psychological and neuropsychological testing and encouraged to do so. As you indicated, her case was transferred to the department's specialized mental health unit when it became pretty abundantly clear that they were best suited to support her. With regards to mother's work, mother's referral to work with the Department of Mental Health, I know there's been a claim that mother was sort of left on her own to figure this out. I would just point to the record evidence that mother had represented that she had had an intake and been told that she didn't qualify. The social worker at the time spoke to the Department of Mental Health, learned that mother hadn't completed that intake, and so she became involved in helping sort of shepherd mother to the Department of Mental Health. So it wasn't just an outsourcing, it was certainly a collaborative effort to have that happen. Mother's action plan, as I indicated, required her to seek psychiatric treatment and attend therapy, but I don't want to take my limited time repeating myself, but that referral for psychological and neuropsychological testing was crucial because the department is not permitted to diagnose mother without some information that says this is what mother needs. There are limitations to the ability to put them into place. The fact that consultation with the department's mental health specialist took place later was separate from the fact that the clinical team was meeting ongoing regularly to say not only what does mother need and how can we tailor the services, but the other question, and this was borne out in testimony, was how can we get mother to engage, because mother was refusing to do so. If I may, I would also like to respond to something that was specifically stated by my brother, because I think it's important. He identified mother's behavior as a cry for help and indicated that she had requested a parent aid. And I would just like to state that until February 22 of 2022, so about 2 months before trial began, mother outright refused to work with a parent aid. In addition, she didn't request a parent aid. She indicated an openness to working with a parent aid. And when the social worker, both social workers I believe that testified, but there was questions asked, why didn't you refer? You didn't refer to a parent aid, right? You didn't refer to these things. And the answer was, I could not do so. If mother refuses to engage, we need releases signed by a parent. There's ways in which a parent has to take some steps to enable the referral to take place. So it wasn't a mere omission of awareness to do it. It was an impediment. I know I'm low on time, but I would just like to direct the court with regard to this issue to adoption of Mario, which makes clear that while the department absolutely has to make efforts to provide the services necessary for a parent to overcome their shortcomings, that parent too has to be involved in resolving or in engaging. So where mother simply refused to now bring that here and lay it at the department's door, I would argue is problematic. I also, if I may briefly respond to a question that was asked earlier. There was a question about whether this was raised on raised at the trial level, and I would argue that it was not. I would direct the panel to adoption of Gregory and adoption of West, which lay out very specific ways in which these matters can be brought. Mother sought no administrative fair hearing. She initiated no grievance process. She made no claim of discrimination under the ADA. She filed no abuse of discretion, and she didn't ask for any services referenced in my brother's brief that would have put the department on notice that she was open. Instead, she refused them. So the fact that she was unable to ameliorate her parenting deficits was not due, as mother argues, to the department's failure to make referrals. It was due to mother's refusal to accept referrals. I recognize I'm very low on time. If there's any further questions.
Thank you.
Thank you very much.
Ms. Appleyard.
Good morning, Your Honors. May it please the Court. My name is Jennifer Appleyard, and I have the privilege of representing the children in this matter. In regard to your question regarding the calendar, the personalized calendar given to mother, I would suggest that the Court should look at the findings 107 through 113, which shows that while she did attend the August 2017 visit, she failed to attend the the visits in September 2017 and October 2017, which were the months after the calendar was given, as well. She did attend the visit on November 2017, and that's finding 113. I would like to address the issue that mother's unfitness is not temporary. Her untreated mental health is not temporary, and it affects her ability to safely parent because of her dangerous behavior. Mother had frequent hospitalizations. She did not seek the follow-up care, which was requested. She did not follow through with the medication. She did not follow through with therapy. As a result, her dangerous actions affected her ability to parent and placed her children multiple times at risk of harm. There was an incident when she fed her children nicotine gum. She did not understand why this was disturbing. The social worker and father immediately requested she remove the gum from the children. She kept repeating, but it's safe, it removes the smoke from the children. It does not contain sugar and it does not contain diabetes. On multiple occasions, she provided inappropriate food to the children, which resulted in potential choking. Oftentimes, she appeared disengaged and unable to connect without coaching from others. And on several occasions, the children ran away twice off almost into the street in September of 2020, and once out of the room, and mother was not at all aware of this. As a result of these hazardous events throughout the years, it demonstrates a nexus between her untreated mental illness and her ability to keep her children safe. In addition, mother's parental capacities are not temporary, and her cognitive challenges are directly connected to her inability to parent because she has failed and continues to fail to learn from the offered services. Specifically, there was a parenting class in which there was testimony that, or there was evidence that mother reported, I believe, to the court clinician that she had learned to be on time, to take the children to appointments and participate in discipline. The teacher of this reported substantial concerns about her parenting and that she felt it was appropriate to hit a baby on the foot. Finally, it is in the best interests of the children to have the lower court's judgment affirmed and that the children's best interest to be adopted. This is supported by conclusions 5, 9, 33, and 36, none of which were contested. The evidence shows that the three children are together and they've been in the same placement almost their entire lives in a loving and stable home. While the children receive some therapy, the pre-adoptive mother is able to satisfy all of their needs. In addition, 2 of the children suffer from asthma, and again, the pre-adoptive mother is able to address these needs. The adoption worker testified that the home is clean, the children are well-nourished, and appropriately dressed. The evidence at trial is that the children are in a stable and loving home where they are happy and thriving for almost all of their lives. Given that the mother's unfitness is not temporary, by the lack of progress in mental health treatment and inability to remedy her parenting deficits, the children deserve the permanency, and affirming the lower court's judgment is in their best interests. If the court has no further questions, I rest on my brief.
Seeing none, thank you. That'll bring to a close today's sitting. I'd like to thank our court staff, our court officers, our law clerks, my colleagues, and the excellent timekeeper. And with that, we will stand in recess.
All rise.